Let's say that you have a battery-operated vibrator.
You know what? We're done right there. We're done. Is there anything further
You're
from
about
you,
to
sir?
climax.
Okay. Well,
The batteries go out.
Okay, thanks.
That's him.
Okay, great.
Today, we're going to be taking a look into the wonderful and pleasant process that is divorce court.
Judge Butterby Court is now in session. Judge, this is case number JVB 1035, Smith case.
Thank you.
You're welcome.
And today, we're going to be taking a look at this Karen, who's going to be making a case for herself to get that sweet, juicy increase in child support money.
You brought this case before the court. What's going on?
Well, good morning. I come here today to try to get his child support raised.
Okay.
We have one child. His business, I'm not 100% sure, but I think it's almost close to 100,000, give or take, like maybe 10 to 15.
Okay.
So I feel like I get a measly $600 a month from him. I feel like
So
something's
that's how
not
much
right.
his child support is
Currently.
set at right now?
Yes.
Okay. Do you make $100,000?
No, ma'am. I have 85 to 90,000 on the high end on a good year.
Okay. All right. What is it that you do?
I'm a mechanic.
Okay. All right. So you said 90 on the high end.
Yes, ma'am.
Okay. I can only go off of what he told me, and he said 90,000 on the high end. I think you're in pretty good shape. What do you do for a living?
I don't work. I take care of our kid.
So you're a stay-at-home mom?
Mm-hmm.
And she's 11?
He is.
He is
yeah.
11?
Uh-huh.
He goes to school?
He does.
So what do you do during the day?
Nothing.
You don't want to work?
No.
So you're just living off of his child support?
I am.
Right off the bat, I think I have a pretty simple solution that would solve this Karen's financial concerns effectively, and that solution would be to get a job. How about working like most parents and not financially relying solely on child support?
So what do you do during the day?
Nothing.
Clearly, the child support she's getting now isn't enough in her eyes if she's taking the time to schedule an entire court session to beg for money. But just imagine if you actually got a job and not sit at home all day like a lazy slob and do nothing, in her own words. Something tells me, though, this self-entitled attitude isn't going to be changing overnight.
No.
So you're just living off of his child support?
I am. And we live with our mother.
And you're proud of that?
Well, we were living with him, and I was a stay-at-home mom. He made the income.
Okay.
But, I mean...
But you can work now, right?
I can, but...
So it's no but you can go get a job, right?
I could, but I'm not going to. My rent's free, my food is free. I mean, my mom's the homeowner. You don't have to pay nothing.
So far, a very convincing case for a much-needed increase in child support. I mean, this sounds like a mom who is just struggling to keep her head over water. What does she have? A rent-free house to live in, good health, free food, free utilities. It really sounds like this is a case where the cards are just stacked up against this person. I mean, from the sound of it, her mommy's already taking care of her. So what is there to even spend the child support on?
My mom's the homeowner. You don't have to pay nothing.
It boggles my mind how you could appear and show your face in front of a court with your chin held up high and make these demands.
I mean, my mom's the homeowner. You don't have to pay nothing.
Okay. You know, I'm not going to go there with you today because you can, obviously you're able to work.
I'm able, but I don't
and
want
you should work, but again, that has nothing to do with me today. What we're going to do is talk about the modification of these numbers, all right? It's $5,465.22 that would bring, well, health insurance. Who covers health insurance?
I do.
And how much is that?
It's 110 a month.
Okay, 110. So what I'm going to do is give you credit actually for the health insurance coverage for the child. So that will slightly bring your child support down. And monthly, yes, slightly. It's still expensive. $1,093 a month is what he would pay in child support.
That's it?
That's it. Well, it would be more if you get a job.
He would pay more if I got a job?
No, it would be more for the child if you got a job.
Your Honor.
Ma'am, no,
You don't understand.
The entitlement is off the charts here. Suddenly, entitled Karens aren't looking all that bad. In fact, they look like saints. I got to admit, I admire how shameless the Mother of the Year is here. She is in this court today, purely to leech and nothing else, essentially.
But you can work now, right?
I can, but...
So it's no but you can go get a job, right?
I could, but I'm not going to.
Voluntarily staying unemployed on top of that, there's absolutely nothing you could say to convince me that the family court system isn't broken if parents like this are still getting an increase at the end of the day. I'm not saying that this mom is a bad parent to her child necessarily, but I'll bet my life that $1,000 a month is sure not only going towards an 11-year-old.
No, you don't understand. I'm basing his child support increase off of what it is that he makes. Nothing
He
more.
makes more than
nothing,
that.
Until you bring me something in here to show me that, that's what I'm going to base it off of. And again, you can work. What is it? Make it quick.
I promise you I'll make it quick. Let's say that you have a battery-operated vibrator.
You know what? We're done right there. We're done. Is there anything further
You're
for
about
you,
to
sir?
climax.
Okay. Well,
The batteries go out.
Okay, thanks.
That's him.
Okay, great. Let me tell you what we're going to do. You all are done, and if there's nothing further, you all are dismissed. Thank you.
That's 200 days. You got anything else to say, Miss Burks? No. That's 300 days.
Next, we go to a bond hearing in Elyria, Ohio. Appearing remotely is the defendant, Ebony Burks. She's charged with misdemeanor assault and domestic violence against her grandfather, Shedrick McRae, and his companion. At the bench is Judge Gary Bennett.
Good morning, Miss Burks.
Good morning.
After reading the charges, the judge asked Burks how she'd like to plea.
You have 3 pleas available to you today. Guilty, not guilty, and no contest. What plea would you enter?
I'm not guilty.
So far, so good. The judge sets bond for the 2 charges at $15,000. His only condition is that Burks not be in contact with the victims, which could be difficult since she shares a home with McRae.
No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him. If you go someplace, even though you may have arrived first and one of them shows up, you have to leave.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with Mr. McRae, you cannot return to that residence.
Oh, but how you just gonna tell me I can't go home?
What?
How you gonna tell me I can't go to my home?
I just did.
Typically, right about now, a lawyer or even a judge might try to de-escalate the situation. But it's clear this is not a typical bond hearing.
How you gonna tell me I can't go to my home?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you got 30 days. So you're not going. You're not what?
Whoa, whoa, whoa.
Get back! Get back!
Hey, you just said I got
Get back! That's another 30 days. That's 60 days.
So what?
90 days.
So?
120 days.
Okay, and?
180 days.
Boom! Get off me! Get your hands off me, man!
It looks like Burks may be finished.
What else you got to say?
Hold on, she's coming back.
Nothing. We'll talk in 6 months when you're ready to come back for your case.
I ain't got money.
That's 200 days. You got anything else to say, Miss Burks? That's 300 days.
Though she racked up 300 days, Burks only ended up serving 88. According to Judge Bennett, it was the longest sentence he's ever imposed for contempt of court. As for her assault and domestic violence charges, they were suspended. But she was forced to enter a substance abuse program.
Sorry, Your Honor.
Not as sorry as she's gonna be.
Next, we're in Williamsburg, Kentucky for a bond revocation hearing. The defendant walking up to the podium is 42-year-old Shannon Fox Hamlin. Today, she's in court for allegedly violating conditions of her probation. Once at the microphone, she lets Judge Paul Winchester know she's being represented by a well-known name, maybe best known for his pro bono work.
And who's representing you today?
I'm represented by Jesus Christ.
That's right. Now a savior he may be. But one thing he not is a licensed member of the Kentucky State Bar. So the judge offers up the services of the public defender's office instead.
All right, so I'm going to appoint Mr. Findale to
No, I
represent
don't
you
want
today.
Mr. Findale. I have that right, Your Honor. And Jesus is going to represent through me. I do not want legal counsel.
Okay, all right, so what do you want to say?
I want to say that I have lived hard, loved hard, played hard, but I've been saved and applied the blood. I'm pardoned through Jesus Christ, okay? I have stumbled and I have failed many times, and mercy's rained from that bench. Not because I deserved it, but because I'm sure somebody prayed. okay? I wanted to taste salvation and play over here too. I was riding the fence between me and you. God gave me a choice, and it's life or death. I kid you not. Do I look like the person that stood before you in August? Do I? I'm humble. I'm gonna walk of shame.
But alas, Judge Winchester has had enough of the courtroom sermon.
Okay, let me ask you a question.
Yes.
Allegation is you failed to report to probation and parole.
Okay, sir. I have nothing in this world.
All I need is an answer.
No.
Did you go? Okay.
I went to probation, yes I did. But the next 2 times I didn't have no right.
In addition to not reporting to her probation officer as scheduled, Fox Hamblin has another violation.
On December the 9th, 2016, you were given a drug test and you were positive for methamphetamine, and that was confirmed by a lab.
Saved by the blood.
Okay, yes or no? Do you acknowledge that?
I acknowledge I'm saved by the blood.
Saved by the blood or exposed by the blood test?
I don't use drugs, Your Honor. I do
understand
not
that.
use it.
You've
I
already
don't.
told me that, but back on December of 2016,
His paper says so, but I will not admit it. He said I could.
are you denying the allegations in this motion?
Yes.
Fox Hamlin's probation officer is then called on to offer testimony.
Back in December, did she test positive for drug use? She didn't.
He's not telling the whole truth, Your Honor.
Okay.
You expect me to, he needs to too.
Hey, let me tell you something now. You can ask him a question.
Okay, have I
Can't
not
preach
been
to
in
it.
contact? When you called me and said the drug test came back methamphetamine, tell the truth, Shannon. What did I say?
I did not call you.
Brian Diggs, you are a liar in the court of Winsburg. I promise you, Jesus is watching.
Okay, let me tell you something. I have to go by what the test
He
says.
is lying,
And
sir.
The
His
test
his
says.
test wasn't right.
What I'm telling you is, I have to go by what the lab says.
Can I make
Doesn't have anything to do with what he said.
Between me and you.
Okay.
Prison is to reform me, right? To make me a good person for
Well,
society. Is
that
that
and to
correct?
keep you from breaking the law.
Okay. Well, do you believe that the blood applied by Jesus Christ can do more reform for me than Pee Wee Valley? Do you believe it can happen in 1 day, 1 minute, or 1 hour?
Well-
Sir, I'm sentenced to death. I'm going to die.
But as the defendant continues to argue, the judge asks the bailiff to escort her out and revokes her bond.
Mr. Engel, can you take her for me, please? Motion is sustained.
Sir, no, I have the right to speak, okay?
And you have the
my
right to
life is
speak.
at stake. I'm going to speak, please. No, I'm going to speak
now.
to this judge. No, I'm going to speak to you right now. My life is at stake. I'll die in prison. Come on, I have a right to. I won't go. You'll shoot me.
As it becomes more apparent that she is not going quietly,
You stand by and have no, I won't go, sir. No, I won't.
another court official enters to help remove her.
No, I won't go. You understand? I won't. No. No. Mr. Winchester, I won't go. No. I won't go. You understand? You'll shoot me before I go. I won't go.
You need to go. You don't
No,
want
I'm
to do
not.
that to you, okay?
You understand? I won't.
You need to go.
You see truth and you're denying it. No. Mr. Winchester, please. I want my family back. I've changed. No, they need Jesus like he's in a hanging on the house.
As the struggle spills into the hallway, Fox Hamblin continues to resist, reportedly kicking one of the bailiffs and causing an injury to his hand. On top of having her bond revoked, Shannon Fox Hamblin was charged with contempt of court, second-degree assault, resisting arrest, and second-degree disorderly conduct. She was sentenced to 8 years in a Kentucky prison. Next, we're in Fort Lauderdale, Florida, for a bond hearing. 28-year-old Tyra Van Zandt is facing a long list of charges, including grand theft and resisting arrest, after she was caught stealing more than $400 in jewelry and purses from a department store.
Hi, how are you doing, sir?
Today, Judge John Hurley will decide if she's eligible for bond, but as Van Zandt waits for the hearing to start, she begins pleading her case to a higher court.
Jesus. Thank you, Jesus. In Jesus' name, say I ask in the shall be released. Please let me be released from this jail for us. Thank you, Jesus.
Unfortunately for Van Zandt, the ultimate judge is not presiding over this hearing. Instead, it's Judge Hurley, who seems caught off guard by the defendant's prayers. Before Judge Hurley dives into Van Zandt's charges, questions about her professional life take center stage.
Are you employed when you're not in jail?
Yes, sir.
What type of work is it? Oh.
I work at Pure Platinum.
Pure Platinum might be considered a place of heavenly bodies, just not in the biblical sense.
I'm not going to ask any further questions along that line. By the way, I don't know anything about where you work. What people say in here, I don't know anything about anything like that.
As Judge Hurley continues to read more details about the severity of Van Zant's crimes, the tone of the hearing begins to sour.
Wow. They had to tase the defendant to bring her down. She wouldn't stop.
A closer look at Van Zant's recent criminal history also reveals this isn't her first time facing very serious charges.
You've been arrested 8 times in a matter of a couple of years. I don't know, it's like every time you go out your front door, you're getting arrested. So she gets arrested, you said in June? She got arrested in June for obstruction, for cannabis and cocaine, and now she has to get tasered in and she wants me to let her out and have a second chance. Huh, interesting.
Please, I'm asking you for a second chance, sir. Please, so I can get my life together.
I wonder what you told the judge after the first, the second, the third arrest, the fourth arrest, the fifth.
Please, listen, I'm in a Christian unit program here, sir, and I've come to found God, and I'm really changing my life, and I just want a chance to be able to go to a rehab, sir.
Right.
Please have mercy on me, Judge.
After a brief pause, Judge Hurley makes his ruling.
Ma'am, I'm going to let you stay in right now. I think that's the safest place for you. Thank you.
Oh, my God.
Tyra Van Zant later pleaded no contest to grand theft in the third degree, resisting arrest without violence, possession of an unlawfully issued driver's license, and criminal use of personal ID information. She was sentenced to 180 days in jail and 3 years probation.
All right, Missy, Jennifer Kangemi.
Next, to Fort Lauderdale, Florida, where Judge John Hurley is conducting video bond hearings with inmates in Broward County.
Ms. Kangemi, you're charged with an aggravated battery. Finds probable cause. Do we have any priors on Ms. Kangemi?
Judge Hurley is then informed that the defendant is 17 weeks pregnant, a crucial fact for understanding the crime.
Okay, so, unusual set of circumstances, 4 o'clock in the morning, and the defendant allegedly threw a cell phone, hit the victim, Mr. Edwards, in the head. The defendant is 17 weeks pregnant, and she stated that she was craving Oreo cookies and became upset when she discovered that Mr. Edwards had eaten her Oreo cookies.
The victim, Mr. Edwards, is the baby's father and alleged Oreo thief. Notice as Judge Hurley reads from the case file.
And she stated that she was craving Oreo cookies.
The defendant can't help but laugh at the absurdity of the situation.
And became upset when she discovered that Mr. Edwards had eaten her Oreo cookies. I tell ya.
But what's not so funny is the injury brought on by her cookie craving.
He received allegedly 3 staples in the head as a result of munching on her cookies.
I think the harm was greater than the intent, Your Honor.
That's Public Defender Dale Miller, and apparently he can relate to the situation.
I know you've been here before. Oreo cookie cravings can be awfully strong. I would ask the judge to be as lenient as possible on the bond in this case.
Before setting a bond amount, Judge Hurley talks through the curious details of the case one last time.
She's pregnant. She's in jail. She's got no criminal record, and somebody ate her Oreo cookies. So
I'm familiar with the facts.
That does seem like a mitigating factor here that we can't overlook. Ma'am, let me ask you, who's going to bond you out of jail?
I don't know. I have the money at my house.
Okay, I'm going to do this, ma'am. I'm going to release you on your own recognizance, all right? I'm going to allow you to have telephone contact with him, all right? You have to stay 500 feet from him at all times. Do you understand that, ma'am?
Yes.
Good luck. Thank you. All right, ma'am?
Good luck, ma'am.
Ma'am.
And before she leaves, Judge Hurley shares one final thought.
Ma'am, can I give you some advice? Hide your Oreo cookies next time, all right, ma'am?
Yes.
Don't let anyone get near them. All right, ma'am.
The charges against Jennifer Kangemi would later be dropped.
This is clearly the most shocking
very much
news we've ever gotten in this courtroom.
For 20 years, this Karen told this man he was the father of her son.
You say you have proof that Mr. Manser is Dylan's father to finally stop him running from his responsibility.
Yes, ma'am.
This is Elizabeth Sear of Southwest Missouri. She told Bill Manser he was the father to her child.
I didn't find out anything about the child until I was served with papers in 1995.
Neither Manser nor Sear disputes that in Southwest Missouri in 1992, they had some kind of sexual relationship.
But as far as intimacy, we was together one time, and I hate to be crude, but it was a one-night stand.
I don't care what your version was. I was far from a one-night stand.
Living across the street from each other?
Far from a one-night stand.
Regardless, she gave birth to a son, Dylan, in January 1993. A couple years later, Sarah ordered a paternity test. The test concluded that there was a 99.6% probability that Manser had fathered the boy. Manser moved to Lake County, Florida, and he was named the father because he missed a court date.
And so you showed up for court, and what
no,
happened?
I wasn't able to show up for court. I was completely on the other side of the state. I was indigent. I was living at my mom's, didn't have a job at the time. So I didn't show up for court, and I was named the natural father by default.
And then what happened?
He ended up paying more than $30,000 in child support to Sear and spent 5 years in prison after failing to pay on time.
And then when I went to prison for 5 years, when I got out of prison in 2003, I paid child support from that day until just February of last year when I lost my job.
Only because they garnished your wages.
Absolutely, that's what they do. And I actually asked my public defender, where's the proof? I've yet to see proof that the child's mine. He said that they obtained my DNA through a sample that was already on file. That's what she's claimed this whole time.
For a daughter you didn't raise too.
So, that's right. I'm not here to win any Father of the Year awards, believe me.
You wouldn't get it.
So, but I'm here to say that, you know, in today's society, I think it's cruel and unusual punishment to be sentenced to 5 years in prison with rapists and murderers and child molesters for missing a court date. Because that's basically what happened. I missed a court date.
You missed being a father.
Sarah herself had good reason to believe the narrative. A paternity test she'd ordered from a lab concluded with near certainty that Manser was her baby daddy.
We do, however, see a lab record of a collection taken on May the 1st, 1995, which they claim was you. Ms. Sear, I see the laboratory results of the testing with a probability of paternity of 99.67%.
But he was never totally convinced Dylan was his son.
Do you know, man, that he said 99.67 means he still might not be the father when he heard that number?
On August 12th, 2013, Manser, Elizabeth Sear, and her 20-year-old son, Dylan, submitted to new DNA tests at a California lab frequently used by the paternity court show. They appeared on the show on August 29th and got a rather different result.
I think it's time for the results.
Yes, ma'am.
All right. Jerome, lab, because of the sensitivity of this issue, ran 2 tests. The results are as follows. In the case of Manser versus Sear, as it pertains to 20-year-old Dylan Sear, Mr. Manser, you are not his father.
Oh, man. 5 years in prison.
This is clearly the most shocking news we've ever gotten in this courtroom.
But the most shocking moment is yet to come. Listen to what this Karen is about to say.
Do you want to find out who your father is?
Of course.
Miss Sear, you know who his father is.
Yes, I talk to him still. Yes, I talk to him still.
You cannot stand there and really suggest that you cannot comprehend why this man would not have any type of ill feeling, frustration, or regret as it relates to anything involving you. 5 years in prison. And then I say, do you know who your son's father is? And you say, yes, I'm still in touch with him. That is a really huge pill to swallow.
Next, we head head to Dallas, Texas for a civil hearing. 33-year-old Amanda Stiles and her ex-husband, Ryan Parnell, are in a child custody dispute. Parnell's attorney, Lacey Kimball, has filed several motions with the court, which include a request that Stiles take a drug test. Today, both parties appear remotely before Judge Drew Ten-Isa to review the motions. Stiles appears without an attorney.
Good morning. How are y'all?
Morning, how are you?
Morning.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Stop talking.
Things get off to a rocky start.
You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
The judge remains calm as Kimball continues.
We also had sent discovery out as laid out in our motion sometime back. We ultimately never got a response.
We got responses. Objection.
Hold on, wait a second. Ms. Stiles, you just need to object, and then let me know what your objection is. Don't yell at her.
Objection to hearsay.
Hold on.
Judge Ten-Eyck presses the mute button on Stiles, allowing Kimball to speak without interruption.
And then we have an order to compel Ms. Stiles to provide dates for a deposition.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond.
Despite her disruptive behavior, the judge moves forward, attempting to get Stiles' responses to the 4 motions in question.
Do you have an objection to taking a drug test?
I use marijuana daily. All day, every day. So I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense, but
Stop. I'm pretty low key. We're in court. You need to be respectful. Just say Judge Ten-Eyck. Okay, it's pretty easy. So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Ten-Eyck.
I'm not interpreting. I just said what you said.
Hey.
What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. What's your response to their motion to compel?
Have you read their discovery?
Ma'am, you need to answer my question.
I answered your question.
All right.
By now, even this low-key judge seems to be losing patience.
So I'm going to warn you that it is completely inappropriate to swear like that in court.
Stiles then pushes her camera away.
You need to take yourself, you need to put yourself back on camera. I'm gonna sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it.
Judge Ten-Eyck tries to get back on track.
In terms of the deposition dates, what's your response to that?
What dates?
Ms. Kimball, do you have proposed dates?
And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Woo woo.
So I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn. I said 2 words.
Ma'am, I don't think you want to do this. I will, as I said, sanction you.
Please do.
Before ending the hearing, the judge tries to get a deposition date on the books.
Which of those dates works better for you, Ms. Stiles?
What time? Dumb. 3 contempts.
Correct, that is 3.
Supposed to start at 9 a.m.
What date?
That question is to you. Never mind.
Said what time? Time, date? You know, these
I'm
things.
not gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. as another violation.
Stiles was held in contempt and ordered to pay $400 in fines. As for the child custody case, Stiles later relinquished her rights to the child, including any visitation rights, and the father, Ryan Parnell, has full custody. Next, we go to a bond hearing in Miami-Dade County, where the presiding judge is Gerald Klein. As he addresses the defendant, keep your eyes on the woman in the background, 24-year-old Nicole Babb. Babb's impromptu striptease gets some chuckles from just about everyone in the courtroom. Everyone, that is, except for the judge. The 84-year-old Klein, whose nickname is Fast Jerry because he moved through cases so quickly, appears unfazed by Babb's performance. Take another look. As Babb disrobes and takes her act to the floor, it's clear it'll take a little more than some full-on nudity to distract Judge Klein. Looks like after 40 years on the bench, Judge Klein has seen it all. Not even a round of applause from the spectators can distract him from the case at hand. After things calm down, Judge Klein is ready for the next defendant, who, of course, is
Nicole Babb. Judge, that was the stripper.
She's still in court.
I can bring her up and hold the garment. CJ, we'll hold the garment.
She's still here?
I got her right.
Judge?
Yes.
They said they can bring her up and they'll hold the garment on her this time.
The situation finally gets a smile out of the judge.
No, she's here, Judge. She's here. Yes, they're just gonna hold the Ferguson garment on her.
She's coming.
A newly clothed Babb, charged with identity theft, approaches the podium.
What's her status in the other matter?
5,000.
Ma'am, are you homeless?
The defendant doesn't stick around to answer.
Not.
He's talking to you. He's talking to you.
No, I'm not. I don't want to stay here. No. She doesn't want to stay, Judge. She wants to leave.
And with that, Judge Klein sets the bond, $5,000.
I mean, I can't even afford to get my nails done, my hair done. It's embarrassing.
Get ready to witness quite possibly the greediest Karen you've ever seen. So it's no secret that in this day and age, it's not uncommon at all to hear about athletes, celebrities, and even people you know in real life getting completely assaulted financially by the court system, unrightfully so. And today we're going to be taking a look at this mom who took her ex-husband to court in order to get some more of that sweet, juicy child support money. And as we're about to see, it backfires on her hard. And of course, this is another episode of one of my favorite shows out there, Support Court with Judge Vonda Bailey.
Okay, Mrs. Williams, you brought this case before the court. What's going on?
Yes, ma'am. We have 3 children together. I have not received any child support from him. Our children go to private school. They play sports, dance lessons, singing lessons. They're very active and it's very expensive. We do share custody and time, but I pay for private school. He pays for health insurance and that's all. I pay for everything else.
What kind of money you make to be paying all of that?
I'm an attorney.
Oh, okay.
But I'm used to a certain lifestyle. I mean, I can't even afford to get my nails done, my hair done. It's embarrassing.
You're an attorney,
yes,
and
ma'am.
you can afford tuition, but not to get your nails done.
Because all my money's going to the tuition and all of their extracurricular activities. I've been sacrificing the things that I'm used to that I was able to do before when we were still together and we had that combined income. And now all my money's going to the kids and I don't have any money left for the lifestyle that I've been accustomed to and getting my nails done and my hair and massages and things like that.
So far, this woman is actually being a relatively good mom, you know, paying for her kids' tuition and activities and whatnot, you know, which is great. I can't say anything bad about that. But what confuses me immediately is why exactly this woman decided to take her ex-husband to court. I mean, she is chasing child support money here. But as far as I can tell, it doesn't sound like she needs any help paying for things relating to the kids. It sounds like she needs help paying for her and her lifestyle, like getting her hair done, nails, massages, which isn't exactly what you'd consider child support. I mean, this just sounds more like an allowance. Like, what was the logic heading into the courtroom? I'm going to ask for extra child support, but then proceed to complain about how I can't get my hair done anymore. Well, yeah, you're a parent, and being a parent comes with making sacrifices financially. I mean, that's just common sense when it comes to having a kid, that you're going to lose out on some luxuries. Immediately, I get the impression that this woman walked into the court and thought this was going to be a slam dunk case for some extra cash. But let's see what happened.
All my money's going to the kids, and I don't have any money left for the lifestyle that I've been accustomed to, and getting my nails done and my hair and massages and things like that.
It's still not making sense to me. Mr. Williams, make this make sense.
You know, although she makes more money, she has an extravagant lifestyle. The hair, the nails, the massage. You know, she didn't tell you about the personal chef or the maid that she has come clean the house every week.
So now it's making sense, okay.
And let alone the drinking problem that you have.
Drinking problem?
The weekly stops to the liquor store to have a curbside pickup. Come on now.
He's telling the truth, isn't he?
Well, you know, after being in court
that
all
wasn't
day,
my question. He's telling the truth, isn't he?
I do like to have a cocktail now and then.
So the answer is yes?
Yes.
Okay. And you brought him to court?
Yes.
For child support?
Yes, ma'am.
How much money do you make?
$70,000 a year. I make $100,000 less than she does.
But again, I pay for pretty much everything. The only thing he pays for the kids is the health insurance.
Health insurance is pretty important. You'd agree with me, right?
It is, and I appreciate that. I do. But I don't want to pull my kids from private school or you know, take them out of the things that they love to do because I can't afford it.
Or you could just, you know, not hire a personal chef. You could stop drinking, and then maybe you could afford it. Maybe you wouldn't have to go to court to get more child support from somebody who's making $100,000 less than you. Also, I don't know why I keep saying child support, because from the sound of it, if she does end up getting more support, that money is never going to reach the children in any way, shape, or form, not in a million years. This woman's primary concern seems to be just getting her hair done, nails, makeup, and massages. I don't know how, as an attorney, she thought she could schedule this court hearing and think this would work in her favor. And I get that this mom is paying for more things, but the fact that the only reason she seems to be here in the first place is to get money to support a more luxurious lifestyle, it's just strange, let alone from someone who's making a lot less money than you. I don't know, it would be very different if you needed the extra support to actually take care of the kids, and not for massages, liquor, and trips to the nail salon.
Don't say that again, because you can't afford it. You're getting your nails done, you're going on trips, you're doing all of these other things, especially going to the liquor store. Alcohol is not cheap. You can't afford it. You're just choosing to do something other than what you should be doing, which is taking care of these children. I'm assuming you don't live together anymore, right? How often are you all exchanging the children?
We have them equally, so that'll be 2 weekends a month.
All right, yeah. You came in here to waste my time. I am not going to make him pay you child support when you make $100,000 more than he does. What kind of lawyer are you? Never mind. So this is what we're going to do. I am going to do the child support calculations for the both of you and subtract it. And the difference is going to go to the person who makes more, which is you. So for mom, your gross is about $12,325.35. Dad, your gross is $5,833.33. Health insurance, you pay it, how much is it?
It's $100 a month.
Okay, you're gonna split that. So $50 for you, $50 for you. How many children? 2 children, right?
We have 3 children between us and 4 total.
3 children, 4 total. Who has the other child? Okay, thank you for telling me that, because that reduces your child support obligation and increases yours. So it comes out to $1,533 per month. And Mrs. Williams, that's what you're going to be ordered to pay to him. Any questions about that?
No, Your Honor.
Okay. Do you have any questions about anything I just said?
No, ma'am.
Okay. Well, if there's nothing further, you all are dismissed.
You know, for being an attorney, this woman is not the sharpest tool in the shed. $1,533 per month? Talk about a backfire. I guess when you're this greedy and entitled as a person, that's going to surpass any logic or critical thinking ability, even for someone who should already know basic laws relating to child support.
How can you imagine? She's his only son. No face. Can't even kiss him on the forehead. That's something I couldn't wrap my brain around. Because they had to see him on a metal slab.
This is Shayna Hubers. She is convicted of murder for shooting her boyfriend 6 times. Hubers appeared for her verdict hearing in the Campbell County Circuit Court in Newport, Kentucky. She was charged with 1 count of murder after shooting her boyfriend 6 times because he was about to leave her for a Miss USA contestant.
My name is Cicely Miller, and I was housed with Shannon Huber. I was like, man, girl, what'd you do? What happened? And so she was like, well, I shot my boyfriend. I said, did you kill him? She goes, yeah. She goes, I shot him in the face. I gave him no job he always wanted. And she cackled. She was like, and just had this cackle, and it just went right through me.
In 2011, 28-year-old Ryan Poston met Shayna Hubers, a psychology student at the University of Kentucky, through his step-cousin on Facebook. They hit it off and began dating. But their relationship was marked by passionate reunions and tumultuous breakups over 18 months. By October 12, 2012, their relationship reached a breaking point. Ryan, 29-year-old at the time, had plans for a date with Miss Ohio USA 2012, Audrey Bolte, a meeting that would never happen.
I believe Shannon just knew it was over. You know, that this was the last straw. He was done with her, and you're out of here. And she wasn't having that. You don't turn your back and say no to her.
During the trial, Audrey Bolte testified for the prosecution, describing her interactions with Ryan in detail.
For some help and a review of some movies that were going on at the time, and he had replied to one of them and left a funny, interesting comment.
How did he strike you?
Funny and smart.
Shayna discovered his plans with Audrey through Facebook messages, which ignited a rage of jealousy and desperation in her.
I got up off the floor and I grabbed the gun and I shot him.
Shayna maintained that the incident was an act of self-defense. However, in the courtroom, the prosecution, led by Michelle Snodgrass, argued otherwise. They contended that Shayna's actions on that fateful October night were not self-defense, but the result of a relationship she couldn't bear to see end. They painted a picture of a premeditated act driven by jealousy and obsession.
So for 3 more times, she raises the gun and fires into Ryan Poston's twitching body until she fired the final shot where she knew it would kill him.
She picked up the gun and said,
"What would you do if I shot you?"
The defense, however, stood firm on the assertion that Shayna was a victim, not a perpetrator. They contended that she had acted in self-defense after enduring an abusive relationship with Ryan.
Degrading her own self-worth. I can't love you. No one can love you. You can't orgasm because you were touched as a child, and no one will ever love you.
Looking back on it, I feel like I was led on. I feel like I was manipulated, used, and abused.
However, the jury was swayed by the prosecution's argument and recommended a severe punishment of 40 years in prison. Hubers' legal team sought a new trial, arguing that evidence supporting her self-defense claim had been unfairly excluded. They also petitioned for her to be recognized as a victim of domestic violence, which could reduce her time served before parole eligibility. Despite these efforts, the jury still handed a guilty verdict.
But I listened to everything that was said in here. I never heard a word or a look that said, I'm sorry to these people back here.
Just once to hear the words, I shouldn't have done that.
As the jury read the verdict, Shayna Hubers broke down in tears.
We, the jury, find the defendant, Shayna Hubers, guilty of murder under instruction number 5.
Hubers was sentenced to 40 years with the possibility of parole after serving 20 years.
It's certainly not justice, no, because justice in this case can't be given in the courtroom.
I don't believe Shayna has learned her lesson. And if she was to get out on parole, I believe she would find another victim. If it was up to me, Shayna would rot in a cell like this. So Ryan's family can have justice that she would never see the light of day outside of a jail cell.